Hello, you have reached Kent County Probate Court. For current hours and location, please press 1. For calls concerning guardianships, conservatorships, or deceased estates, please press 2. For calls concerning mental health treatment, please press 3.
Good afternoon, Probate Court. Karen speaking.
Hi, Karen. My name is Brittany Martin. I have an issue. My estranged mother, she filed a petition for a mental health order for involuntary psychiatric hold on me in September of 2021. I didn't know that it existed or that she had done that until recently. I honestly came across it on a whim, doing name searches on the online case search on Access Kent. So upon finding it, I came down to the court the following morning to look at the case file and figure out, what was going on. And I saw what she had written, which wasn't, I guess I was a little bit shocked that even with what she wrote, it was that easy for her to do, but also that she straight up lied, perjured it, because as I was reading through the statutes and everything going on with how the mental health code works, you have to have a psychiatrist or an evaluation within 72 hours prior to the petition that has, the psychiatrist has to make a finding that this person does, in fact, it's their opinion, they need involuntary hospitalization. She said that she tried to get me to do that, but I was refusing. And therefore no appointment or evaluation could be obtained, so that she filled out that affidavit, said, that was what happened. That never happened. So she just straight up made that up. Obviously, if
okay, so I'm going to stop you right now.
Mm-hmm.
This happened in 2021. We're 2 years past it.
Right.
And now what are you wanting to do?
I'm wondering what type of recourse there is, because, it's public record.
You would need to get legal counsel, because if you want recourse after 2 years and you want to go after your mom for whatever it was she reported on that petition, you would need to get legal advice, because the clerks in the probate office, we are by law not allowed to provide any because then they say we're not attorneys, and all we can do is push the paperwork forward that we receive.
I get it. I don't want to put you in any type of position. I worked as paralegal at a law firm, so I get the gist. I'm not so much asking for, what is my recourse in terms of damages with her. I just don't want my name on there. Like, if I type in my first and last name to the, website, it comes up that I was ordered, that there was an order entered that I'm a mentally ill person that needed to be,
transferred. Not that you're mentally ill. It's an alleged mental illness at one point. And if you were never picked up, that petition is dismissed.
Correct, but it's still like, it's not like you can access the full court records or anything. It just says, I mean, the case, assignment or whatever, it says the window is mentally ill, and then it says that there was a petition entered, and an order entered for, pickup and evaluation, and then, 2 weeks later it just dismissed, which, I know it's totally, malicious and bad faith, and I know what happened, but that's not, public knowledge per se. So I just don't want, that's just can be really, unfortunately, damaging, and that's exactly what her intent was with her actions of doing this. So I was just wondering if,
again, legal counsel is what you're going to need, because there's nothing that I can do differently when those papers have been filed with the court and they come to us through Network 180, our community mental health provider, who believes in all good faith that what they are being told is accurate information. And then whenever the person is not picked up, we dismiss the petition. But if you are asking for something more to be done so that you don't have an MI case file number on you that stays with a person for life, like any medical record case number might stay with a person,
yes,
then you would either need to seek out your own legal counsel, or the other thing you can do is complete what's called a petition and order form addressing your concerns on that. That can be put before a judge to review and decide if they're willing to take further action on it, or if it stands as it is.
Okay. And
those are the only things that I know.
Yeah, no, that's okay, and that's pretty much what I was looking for. I just would I file that within the case, or would I file?
You would use the case file number that's on it.
Okay.
You would address it as the case file number that has been assigned to the case.
Gotcha. Okay.
And then you would fill out the form. You would file it with probate. Probate then puts it with the file, gives it to the judge to review. And if the judge says, yeah, go ahead and set it for hearing, we'll hear what's going on, or they're saying, no, this is as it is, and we're done. And then we send in the mail of the person the appropriate paperwork, whether it's the petition and order signed by the judge that's denying any further action, or whether it's, appointing with hearing date information.
Sure.
And if a person is requiring attorney assistance with that, they would need to also place that information on the petition and order that they're requesting for an attorney. But otherwise, you need to find your own attorney and, work with them on this matter.
Yep. Okay. All right. So it would be public defender, kind of.
That is something you would need to decide. Yeah.
Okay.
That would be up to you.
Okay. Thank you so much.
Okay.
That's what I was looking for. Yep.
Okay. All right.
Okay.
Have a good rest of your day.
You too.
Bye.